make the requirements applicable for conduct that they believe doesn't constitute being a public insurance adjuster.
That is correct, and we state clearly that that is not the case when it comes to the 14th Amendment challenge. That the conduct that they plead in their pleading, in which they brought before the trial court, including a statement where they had a contract where they were authorized to settle and to settle claims on behalf of their clients. Those allegations fell within the purview of how TDI and the statute defines public insurance adjusting. So, that may be a fact question as to whether or not it actually meets public insurance adjusting or not. But they are simply claiming here that the public insurance adjusting prohibitions categorically implicate the First Amendment, and that is not the case.
Well, then how are we then properly in a Rule 93 dismissal?
We are, Your Honor, because Stonewater alleged that they were potentially in violation of the chapter and that they were seeking relief from a potential violation from another lawsuit. And so as they pled their facts to the trial court as to what it was that they wanted to engage in, that fell under the purview of the public insurance and the public adjusting prohibitions. And that is why we filed a Rule 91A motion at the time, because that was implicated under both their claims under the 14th Amendment and the First Amendment.
That the lawsuit that you just mentioned, is that the one where one of their customers filed a complaint?
That's correct, Your Honor.
So that implicates a situation where Stonewater was the contractor and allegedly engaged in public adjusting.
Yes, Your Honor.
So that is implicated.
Yes. Yes, it is implicated. And that was why the 91...
The closer question, to paraphrase what you said earlier, may be involved here. Not just this general thing about Stonewater. We can poo-poo Stonewater's argument because they don't have a license under that other portion of the statute. 163, whatever, is also implicated. It doesn't matter whether they have a license. You're just saying they can't do it.
That is correct, Your Honor, because 163 states that you may not advertise to adjust claims on property even if you hold a license and you're a contractor. But because Stonewater admits that they are not a contractor, that hypothetical under 163 where you have a contractor that holds both a license to practice as a public insurance adjusting and as a contractor doesn't apply. They brought both an as-applied and a facial challenge to the entire statute. And because they brought that statute, they have to demonstrate that they are aggrieved by it and that they have standing as to all of those claims. That hypothetical plaintiff, who might theoretically be aggrieved of that statute and could have a much better First Amendment argument, is not before the court here today. That's implication.
This other lawsuit that was mentioned, was that mentioned in the pleadings?
Yes, Your Honor. In their petition, they referenced it's a Kaufman County District Court case going on at the time. I believe the case had yet to be resolved. It was just ongoing, but they cited it as their ongoing harm and why they were likely to be harmed by the statute's implications and its implementations against them.
So your standing argument doesn't really apply to that, right? Your standing argument applies to whether they're licensed or not. It doesn't apply to this issue on whether there's a complaint against them for doing something in violation of the statute anyway.
Generally, yes, Your Honor, because they brought a facial and as-applied challenge to the text of the statute, stating unequivocally it violates the First Amendment because it requires us to look at the content of what is being communicated. And that is not the law of under the First Amendment. Certainly, that comes into play when it is first found that a statute implicates the First Amendment. But the public adjusting prohibitions don't in this instance because it's merely first of all, 051 is merely a licensing requirement, no different than licensing the practice of law, licensing the practice of medicine, licensing various vocations in the state.
Maybe, I guess what my point is, and I think what the Chief was asking about just a minute ago, if there's something that still involves a complaint against this specific appellant under these circumstances, at minimum, that's an as-applied challenge. So why do we get to a 91A dismissal on an as-applied challenge just based upon the state of the pleadings that we have right now?
Yes, Your Honor. Stonewater did speak about the defined and the developed records in the other case, But 91A motions are similar to 12B motions, where we have to give deference to and treat all factual statements pled as true and ask if that raises a First Amendment challenge or actually meets the standard under the law, if there's any basis in law. And here they have an as-applied challenge under the public adjusting prohibitions, and it states that you need to have a license to practice as a public insurance adjuster. Mere licensing requirements don't run afoul of the First Amendment unless you look at the text and you find specific instances where that might be an implication of that. Stonewater does bring this court's attention to a case called Edwards versus District of Columbia. That's a D.C. District Court where a licensing scheme was found to implicate the First Amendment.
Right, but one thing that is true about Rule 91A and Rule 12B6 is that you've got to have no set of facts that would put us into the petition or the complaint that's being made. So I understand, maybe they pled too broadly on some of the things, and maybe they weren't prepared or in the right spot to plead those, and I would obviously disagree with you on that. But with regard to these more specific allegations, do we still have a Rule 91A problem there?
I believe we do. Well, not a problem. We believe 91A is still appropriate in that instance, Your Honor, because Stonewater admits they don't have a license. So if we look at their conduct and we look at the fact that they don't hold a license, and then they look at what they're alleged to have done, which is hold themselves out as if they could adjust and settle claims, and have a contract with a client where they could settle their insurance claims on their behalf. Without a license, they run afoul of 051. And they run afoul of 163 regardless of whether they actually had that license, because on the onset, they don't have a license to begin with. So they can't advertise. And that was the case in the Ford Motor Company that we cited this court's attention to from the Fifth Circuit in 2001, where the court said there that a restriction on advertising doesn't run afoul of the First Amendment if the underlying conduct is illegal. And it's illegal to practice as a public insurance adjuster without a license in the state. So likewise follows you cannot advertise as much. The U.S. Supreme Court said as much also in Virginia versus Bigelow. It turns on the legality of the conduct and the legality of the action that the entity wants to take part of before you can determine whether the advertisement is under the First Amendment or not.
So your argument is that this legal question turns on whether they have a license or not. If they had a license, you said the law might be different or the outcome might be different?
Certainly that question is a lot closer, yes, Your Honor. I don't concede that it would necessarily be different, but it's a lot closer of an issue. They don't have a license. So 051 is simply the requirement that you have a license to practice as a public insurance adjuster. And 163 is similarly, you must have you may not advertise or adjust claims on the same property, regardless if you have a license. But because they don't have a license, they don't even meet that issue.
I guess we're looking at the record may not help because we're here on a Rule 91A motion, but is there anything in the pleadings to say they've applied for a license or that they've been denied the opportunity to get a license based upon their status?
No, nothing like that was stated in the pleadings, Your Honor. It was just simply that they admit they did not have a license, they had engaged in this particular form of conduct and had a contract with the client, and as a result, they were subjected to potential violations of the law, and that's why they challenged it. And turning to kind of their main argument on that notion about this touches and concerns speech, and they brought up the professional speech doctrine, I think it's important to clarify what that doctrine actually was. It was a federal doctrine that had come out where after the First Amendment had been found to be implicated, if it was professional speakers involved, then there was a lower standard rather than strict scrutiny that was applied. And in NIFLA, the U.S. Supreme Court completely disavowed in that and said, no. The First Amendment is always a question about whether or not it is, if we're engaged in First Amendment, implicating First Amendment speech or conduct. And I think that that's kind of what's important here, is that we've never argued that the professional speech doctrine exists. We're not arguing that the public adjusting prohibitions are under a lower level of scrutiny. Rather, we were arguing that it wasn't implicated at all. And the cases that Stonewater cites to kind of bear this out. The example they...
Maybe this is off topic. How is public adjusting defined?
Yes, Your Honor. Public insurance adjusting is defined as it means a person who, for direct, indirect, or other compensation, acts on behalf of an insured in negotiating for or effectuating the settlement of a claim. Those are very broad terms, but they're, and I want to bring this court's attention to a U.S. Supreme Court case called Rumsfeld versus Fair. We cite to this court's opinion in our brief. The court there said that conduct doesn't implicate speech merely because there are words being articulated. If that were the case, every single profession would fall under the First Amendment's jurisprudence. That has never been the law in the United States. And to kind of point out the specifics of the cases to show what I mean here, the auto case is actually a great example. The law there said you could not do conversion therapy. So it was targeting specific conduct and specific speaking conduct in particular because it was therapy, in pure speech-based therapy. And that specific target implicated the First Amendment. But a generalized requirement to hold a license to practice as a therapist, that wouldn't implicate the First Amendment, at least so far as the statute just said you have to have a license. We are asking that this court look at the language of the statutes and determine whether or not they implicate the First Amendment in that instance.
And it's for compensation?
Yes, Your Honor. It's direct, indirect, or any other compensation. So,
What about the cases opposing counsel discussed a while ago regarding the practice of law, that providing advice implicates the First Amendment?
yes, Your Honor. In those instances, that very well can happen. And I'll kind of bring this court's attention to the District of Columbia case, because there the district court did find that a mere licensing requirement for tour guides did implicate the First Amendment. And that was because of the facts of what was implicated. It was a license to essentially do tour guides, which was nothing but speaking, and it wasn't on any specific or particularized knowledge other than just a layperson getting a license. That's distinct and different from other professions where there is particularized and specific need to understand a client's case and give the correct advice or give the correct resolution to what it is that the client needs, which would be similar to the practice of law, would be similar to the practice of medicine, and is the case with the practice of public insurance adjusting. And that's kind of what the implication is here. Stonewater isn't prohibited from talking about insurance or understanding how the insurance world works within their world and contracting. What they are prohibited from doing is effectuating a claim on behalf of their clients without a license, and they're also likewise prohibited from advertising to do so on property for which that they could also be giving contracting services for. So, in the first instance, pure licensing requirement to practice as a public insurance adjuster. In the second, it's an advertisement, but the underlying conduct is illegal. You don't have a license, you can't advertise similarly to do so. There is I think to kind of bear that out, there is a U.S. Supreme Court opinion called Village of Hoffman Estates. And in that case, that was a regulation that targeted the advertising of, let me make sure I get this correctly. It was targeting the advertising of the sale of items displayed or within proximity to literature encouraging illicit drug use. And the court found that that did not implicate the First Amendment at all, even though the plaintiff there was targeting it and was actually advertising or at least had literature. Because the point of the law was to say, well, illicit drug use is not legal, so you can't likewise advertise around it as well. Turning to the 14th Amendment's argument here about the void for vagueness, Stonewater states that it's an entirely different matter when it involves the First Amendment. And that might be true. We certainly contest that this does not implicate the First Amendment. But the case they rely on, State v. Doyle, is a criminal case. And in that instance, the law that the Court of Criminal Appeals relied on was an established law of criminal law where vagueness required more specificity than a general civil law. And what the CCA didn't do was overrule U.S. Supreme Court precedent on this, both Holder versus Humanitarian Law Project, as well as the Fair case I cited to Your Honor earlier. And in that instance, the Supreme Court states the first inquiry is to determine whether or not the complainant's conduct is clearly prescribed. And if it is, you go no further. We don't look at the facial invalidity as to anyone else because it's already valid as to at least the plaintiff before the court. And to kind of crystallize this, there are two distinct challenges here. There's a First Amendment content-specific challenge. There is a 14th Amendment void for vagueness due process challenge. The Supreme Court has separated these two challenges and has stated clearly that they are different standards. It is only when the First Amendment's overbreadth doctrine is implicated, and in that instance, overbreadth, where it's a different standard and it's a different requirement, the complainant can challenge a law as it's vague as applied to others. But it's a First Amendment overbreadth challenge that they never pled or argued before the trial court or in their petition. So that is...
Texas legislature would enact a statute that says thou unsafe conduct that supports abortion. And then they said, but only doctors can because they have a license. And is that permissible? For somebody who does not have a license, is it permissible to prohibit somebody who does not have a license? We got a statute that says the speech is prohibited, is wrong, it's illegal. But we can license it.
Yes, Your Honor, I'll give two answers to that. The first would be, if the statute said you may not advocate for abortion unless you're a doctor, certainly that would likely run afoul of the First Amendment, or be a much more closer call.
Why?
Because it's implicating more than just the practice, the medical procedure of an abortion. It would be the equivalent of stating that we just simply do not allow the practice of abortion in the state of Texas. And
This is implicating the ability for somebody to advise another person about dealing with insurance companies.
yes, Your Honor, we don't take the position that advising how to deal with insurance companies themselves necessarily always runs afoul of the public insurance adjusting. I think,
It can if they're getting some indirect compensation.
certainly in that instance, Your Honor, and then that instance they would be practicing as a public insurance adjuster. I think that's the key. To your hypothetical, that would be a statute that would be very broad, and it wouldn't be just focusing on the practice of performing an abortion or providing services for an abortion.
Depends on how serious the political nature of the topic being brought.
It doesn't turn on that, Your Honor. It just turns on the terms of the statute and turns on the question about whether or not they are they implicate the First Amendment. And if I say I'm running out of time, I follow up with the second argument there. The other issue would be advertising in that instance, and the U.S. Supreme Court stated unequivocally in Bigelow that if the underlying right or the underlying thing that is being advertised is legal, then an advertisement is subject to the First Amendment and cannot be restricted. But when the underlying conduct itself is illegal, so, in your hypothetical, Your Honor, if abortion was found to be not a constitutional right anymore, then certainly that's a different question. But today, that is not the law right now. That advertisement would likely implicate the First Amendment because the underlying right itself is legal.
Well, public insurance adjusting is not per se illegal. So would advertising public insurance adjusting type services be illegal if you don't have a license? I'm trying to figure out, under B, a person who advertises, solicits business, or holds himself or herself out to the public as an adjuster of claims, that's not an illegal act in and of itself, but that seems to implicate the First Amendment.
It certainly might, Your Honor, in an advertising situation, but again, advertising to adjust claims in that hypothetical, Your Honor, without a license would not run afoul of the First Amendment under the Ford case because the underlying right, or the right to act as a public insurance adjuster, you don't have a license to do so, so you can't advertise.
Would it under Hoffman Estates?
Same there, Your Honor, yes. Because Hoffman Estates was, again, another situation where the attack was on the First Amendment for saying, I can at least sell or show this literature, and the court there said, it's just selling, and it's around illicit drug use. So not only does it not implicate the First Amendment because it's merely sales, but moreover, you can't advertise because drug use is illicit. And because that is illegal, you can't likewise advertise for it. Otherwise, you would essentially negate any ability to decriminalize or illegalize anything. The advertisement itself would essentially allow every rule or every law, every profession that someone practices that would then be subject to First Amendment scrutiny because a layperson could advertise that they can do what they do without a license. And that would negate the licensing schemes that the states have set up.
Thank you, Counsel.
Thank you. We ask that the court affirm the trial court below.
Chief Justice Quinn, I think your hypothetical got right to the crux of the issue. That was actually part of the dispute in NIFLA. If the court reads that decision, what you'll see there is an argument being made by the state of California in that case, that the crisis pregnancy centers could not or were required to post certain notices because that speech was just incidental to the medical practice of an abortion. It was in some way related to an abortion. That argument was rejected. There was no separately identifiable conduct that they were performing. It was simply advice. It was simply giving information, dispersing information. And similarly here, there is no separately identifiable conduct. There is no, other than the practice of public adjusting as defined by the statute is speech. And this argument that it's going to apply to every profession, I would encourage the court to go read Justice Breyer's dissent in Reed, in NIFLA, in Barr. He makes the same argument that, oh, this is going to apply to everything. The reality is it's not, and the reason for that is because there are historical exceptions to the First Amendment where the First Amendment does not apply to certain types of speech. That would be fraud, for example. And there's no right to go out and make misstatements of fact and false statements. The state can prohibit false statements and fraud that's committed by insurance or by contractors to consumers. That's perfectly fine. But it's these type of prophylactic, preventative laws that try to prevent any fraud from happening that run afoul of the First Amendment, and that's exactly what we have here. The idea that this is a mere licensing requirement, the court needs to look no further than the definition of public adjusting. I don't want to beat a dead horse here, but we are challenging both of the provisions, both the contractor-specific provision, which again, it's regardless of whether we have a license or not. I was hearing an argument about standing that I've never heard before. That is not alleged in the 91A motion. It's not a basis for dismissal that we've heard until today. So that issue is not before the court. Both of these provisions have been clearly challenged, both the contractor-specific provision and the more neutral requirement of a license based on that same definition of public insurance adjusting. Those are both challenged by Stonewater in this case. And getting to the as-applied challenge, we didn't really address that on the First Amendment side, but that was never challenged in the 91A motion. We briefed this issue. The state says that it was impliedly decided by the court.
But the as-applied challenge encompassed apparently that case that apparently was referenced in your petition over a customer's complaint.
Yes, Your Honor. It does. It is based, our standing, if we were to get into that, is based on that case. Where it's actually in current litigation right now. It's pending before the Kaufman District Court. And the idea that we have to have specific subject matter and to be content-based, Reed went much further than that. Reed said that some facial distinctions are based on a message or obvious, defining regulated speech by particular subject matter, but others are more subtle, defining regulated speech by its function or purpose. That's what we have here. The function or purpose of the speech is what determines whether the statute's been violated. It's not just negotiating in the abstract. It has to be negotiating for this specific purpose, negotiating to settle the claim.
Do we know from the legislative history why contractors were carved out of the group of people or entities that can act as a public adjuster?
Your Honor, it appears from the legislative history, and some of this, I believe, is cited in the petition and in the appellate brief, in our opening brief. There was a concern that contractors would be taking advantage of consumers and showing up and offering to, they get a free roof if they sign up with them and they handle everything with the insurance company. That was a particular concern. But there's also a concerted effort by public adjusters to be licensed and to exclude contractors. I mean, that is a form of a monopoly, if you will, that they are going around. That's why they filed an amicus brief in this case. And they would love to be licensed so that they can exclude contractors from this market and force people to pay a percentage of their claim to hire them to negotiate on their behalf, when most people don't need to hire somebody to actually take a chunk. And that's not really an issue before the court, right? That gets into the later stages of whether this is necessary, but that is kind of the underlying dispute going on.
The lawyer who agrees to represent an insured this insurance company because they didn't fix the roof right, is considered a public adjuster. He's trying to negotiate and settle a claim against the insurance company for damage to the insurance company suing on policy.
Would a contractor?
No, with a lawyer.
Would a lawyer? A lawyer is specifically exempt in the statute. Yes, Your Honor. I see my time's expired. Thank you for your time, Your Honor.
Now,
Thank you, counsel. Your case is submitted, and you are excused to go. I want to again thank you for traveling up to Amarillo, and I hope you have a good rest of the day and safe travels back.